there's a couple of basic foundations to what we're going to be talking about today that if you understand these principles, which I'm sure you do, you will understand everything that surrounds these principles. So, two key principles. Property is either more or less vulnerable to creditors depending on how title is held. So, a couple of simple illustrations. I have a $5 million investment account. It's a hypothetical, by the way, in more ways than one. So I have a $5 million investment account. It's held in my own name. I suffer a judgment. What happens to the $5 million account given that the judgment is an $8 million judgment? Very succinctly put. Gentleman in the front says, gone. Now, let's change the facts just a little bit. Let's say that I, a few years earlier, had put the $5 million managed account in a family limited partnership. Depending on what state that partnership is in, Nevada, where we are, Colorado, Utah, Wyoming, Florida, depending what state we've domiciled that thing in, and maybe another variable where I live. But depending on those sorts of things, it might be a little more difficult for the adversary to get at that $5 million managed account if I have an $8 million judgment creditor. Change the facts a little bit. Let's say that $5 million account is in a Nevada Asset Protection Trust. Maybe a little more difficult for that adversary to get at the $5 million investment account. Let's change the facts a little bit. And the $5 million is in a Cook Islands trust with the funds custodied in Switzerland. And as I say, the trust itself having the proper law being that of the Cook Islands. All the more difficult. So we have a bit of a continuum, illustrating the point that property is either more or less vulnerable to creditors depending on how it's held. So part of what we do in integrated estate planning is simply look at the mix of assets, determine how it's titled, and change it from vulnerable title to less vulnerable form of title. Very simple concept. Move things around so that if something happens someday, the way the property is titled and held is in a more protective nature. Second concept. Creditors generally can collect only against what one owns and not what one formerly owned. So it's ownership of property that's the link between the client and danger. So, in a sense, what we help people do is become former property owners. That's the essence of it. And that's the beauty of a trust, truly, is that because a trust will enable one to, A, divest property into the trust, divest title to and in favor of the trust, and B, retain certain elements of benefit under the trust, and C, retain certain elements of control over the trust. And it's not all black and white. It's not complete control or no control, and it's not complete benefit or no benefit. There's a lot of shades of color in between those extremes, a lot of ways to design these trusts. There's a lot of ways we can design these things, but the point is, part of what we do is divest title in favor of a trust so that we break the ownership link because it's ownership of assets that exposes those assets to the risks associated with owning the assets.